Hey there, Natalie Teston, family law lawyer here in Northeast Georgia. I'm here to talk to you today about service. Anytime we file a civil case, such as a divorce, a petition for legitimation, a modification of custody, or what have you, we have to get the defendant served with the action. The defendant has to have their due process rights. They have to have notice that this case is going forward. And the way that we prove that they've got that notice checked off is through proof of service. There are 2 or 3 ways that you can serve defendants here in the state of Georgia. One is the easiest way, which is through an acknowledgement of service. It's literally a 1-page document that says, I, defendant, acknowledge I have been served with these documents. They're usually listed out. The defendant signs that. It gets signed in front of a notary and gets filed at the clerk of court. And the acknowledgement of service will say, I waive any further formal process of service. And so that is the proof that's then in the judge's file that the defendant has been properly served with this case, knows what's going on, has had their opportunity to come in, be heard, file motions, take action in the case. The other way is more formal in nature. You can have the sheriff, the civil process division of the sheriff's office of the county of the defendant's residence, go and serve them with the paperwork. Now, anytime the police are at the door, it's an uncomfortable situation, but they don't come guns blazing and lights blaring, sirens, the whole 9 yards. Usually they take kind of an old cruiser and come to the door very calmly. Are you the defendant? Yes, hand the paperwork, and then leave. And they can leave the paperwork with any other adult who lives at the home as well. So sometimes that's easier to accomplish if someone is traveling for work or something like that. And so then the sheriff actually signs the entry of service. I, Sheriff so-and-so, served this person at this location on this date with these documents. And so that's the document that gets filed in the judge's file with the clerk's office that tells the judge defendant has been properly served and the case can go forward. There's sort of a hybrid of these two, which is the private process server option. We've got many private process servers that we use, and the benefit of using them is that we can have a better layer of communication with them. So in a case where we want to make real sure that the spouse and the kids maybe have left the home or in a safe place before we do file such a thing and perfect service, then sometimes we do work with a private process server and tell them, here's the place, here's the date, here's the time, and they will report back to us immediately, got this person served or did not, gonna try again on this day and time. And so sometimes that's a good option for us to have in our back pocket. So again, that person is someone that has been vetted out by the court system, that is officially appointed, and so the judge knows that the right person, a trustworthy person, is being honest when they say that they did serve this person and they served them appropriately under the law. So service is one of those things that we talk about in every case, and one of the things that we talk about very quickly in the case because that's one of the first things that happens. It doesn't take too long to draft up a petition or a complaint and get it filed. That's e-filed these days, so that happens in a matter of seconds. Really, what do we do next? How do we get that defendant served is usually one of those first topics of conversation, and something that can vary from case to case. In a case that's uncontested, everyone knows we're getting divorced, we've even talked about some terms, well, we're probably going to try the acknowledgement of service route first. We can send everything to the defendant with a cover letter. Please sign the acknowledgement of service. If we don't get it back from you in 10 days, we will have to pursue formal service with the sheriff's office. Look forward to your cooperation. And a lot of times that will work. In cases that are hotly contested, then we're probably using one of the other alternatives. To send the sheriffs out usually cost about $50. To have a private process server serve, it's usually $100 or to $200 per attempt. So again, it's a little more pricey, but in cases where we don't want to jeopardize safety, then that's money well spent. So we can't really move forward with the case until we get the defendant served. The judge really won't come in and do anything. At most, they may do some very limited emergency custody order, but typically those orders are going to say this expires in a week unless you get the defendant served, or come back in here in a few days and prove to me that you've served the defendant, or else this order's going away. So the court really doesn't want to do anything without making real sure the defendant has their due process rights checked off. And as far as the case goes, the defendant's answer is due 30 days after they're served. So I can't even get an answer until I get service. Discovery starts when the answer's due or when it's filed. So again, my timeline to get discovery going is blocked up if we can't perfect service. So service is that first domino that we need to knock over to make sure things start moving forward in your case. Now, of course, this isn't legal advice. As I've said, it really depends on the particular circumstances. We try different avenues and we use different avenues in different cases for different reasons. So if you want to talk about service in your case, then give us a shout and we'll be happy to talk to you about that and give you some real legal advice that's finely tuned to your particular case. Thanks, guys.